Well, good afternoon, everybody. My name is Sandy Chen, and welcome to the Samfiru Tumarkin live employment law show. We're live on YouTube and Facebook, so welcome, everybody. So I'll be here for the next half an hour or so. I know I'm just a few minutes late, and I apologize for that. But I will be here for the next half an hour answering any and all questions related to employment law. Whether you're having any issues in the workplace, any issues concerning your boss, overtime. There's a lot of issues that I guess could happen at work. So anything and everything to do with employment law. If you just want to type in your questions into there should be a box in front of you. I'll be able to see it on my screen here. I can't see anybody, but obviously everybody hopefully can see and hear me. So I'll just read your question and then I will try my best to answer it. So please feel free to ask any and all questions for the next 26 minutes. Take advantage. It's basically free legal guidance, I'll call it. Oh, hello, Kevin. So I don't have any questions for now. I just for all the my normal viewers, I guess I'll call them. I'll start with some updates in employment law. I had a list of 2 or 3. The first one is most people in BC have probably got the or that are covered by the Employment Standards Act, which is most employees in BC. Hopefully you're aware of this new paid sick day that the government has implemented. So it's 5 sick days per year. It's based on a calendar year now, which is the most recent news. Before it was kind of prorated to your start date. So just be aware, quick update, it's actually based on the calendar year. So even if you started in like June of this year or July or midway through the year, you'll have access to those 5 days. Okay, Kevin, so you have a couple of questions. Yeah, Kevin, just type them out. I'll try my best to answer, and we'll see what we can do. So everybody be aware of the new paid sick days, hopefully. The second thing I had on my list is if to the start of COVID 2 years ago, I'm sure everybody remembers. It was mid-March of 2020. A lot of employees were temporarily laid off. Okay. And by now, obviously, if you haven't been recalled, it's most likely a termination. Okay. If you're temporarily laid off and you haven't been recalled, you're probably entitled to severance pay. So this is stuff that happened 2 years ago. What's important for people to know, and if anybody has any friends or family that went through a similar situation, is in BC in general, you only have 2 years from the date of that temporary layoff to actually start some sort of process to get that severance pay. So it's very important if you know any friends or family that had that similar situation when they were laid off during COVID, your timeline might be coming up. Now in BC, the government's made some exceptions to the deadline, the 2-year deadline, the limitation period, as it's called. You might actually have some extra time beyond the 2 years. I wouldn't risk it. There was new regulations passed by the provincial government to suspend these deadlines, but just I wouldn't necessarily rely on that. Assume it's 2 years. And if you want severance pay because you were temporarily laid off, during the beginning of COVID, just be aware your deadline might be coming up soon. In any case, if you do, reach out to a lawyer and they can obviously tell you if your deadline's passed or not. Okay, so I've got a question here from Kevin. Are labor relations war arbitration decisions binding? Yes, Kevin, they are. They're arbitration decisions in general are binding, and there's an arbitrations act in BC, and in your case, I mean, the Labor Relations Act probably mandates that it's binding. So yeah, so everybody be aware that there's deadlines for these kind of things. So most disputes in employment law, the deadlines will range from 90 days to 2 years. So unfortunately, you don't have unlimited time. I know that I often get calls. I don't want to say often, but I do get quite a few calls where people ask me about, stuff that's happened 4 or 5 years ago. They watch our show or they read something on the internet and they think, well, sometimes, and they think, well, oh, I'll just call in and maybe I can get some severance. Sometimes because too much time has passed, you might not be able to do it. So my suggestion to everybody is, if you have something happen at work or if you're let go or if you're fired, you should probably get some advice on it as soon as you can, because in some situations, in specific, if you're federally regulated, there's very short deadlines to do something about whatever's happened at work. So just be aware of that. Um, so, and Kevin, sorry, I'm just, I know you had a couple questions. I'm not sure. I only see one. But if you want to list out the other ones, see a few more comments here as well, but no questions. Okay, so the other recent development, in BC at least, I know we have some viewers here from Ontario, but it probably does apply to you in some respects. And this is a pretty common issue that comes up is recording in the workplace. So I get asked a lot if something's happening at work or if you suspect something's happening at work, if your boss is harassing you or a coworker's harassing you, or someone's asking you to do something illegal at work, should you record it without the other person knowing? And my advice is usually depends on the circumstances, obviously. The recent case that's come out, I think it's probably just from a month or two ago. It's a case in the BC Supreme Court where an employee was fired. I believe the basis is without cause, and the employee sued the employer. And during litigation, there's a process where you get the other side's evidence, right? You get to ask questions to the other side under oath. So in the States, it's called a deposition. In Canada, it's called a discovery. Anyway, so the employer finds out that through this discovery process, that there were, I forget the exact numbers, 50, 100, 150 recordings made, secret recordings by the employee during his employment. So obviously, when the employee made these recordings, he didn't tell anybody. He didn't tell anybody that he was recording. So you can call them surreptitious recordings. The employer finds out through litigation and says that, well, this was a huge breach of privacy, confidentiality, alleges just cause for termination. The judge ultimately rules that the recordings were a huge invasion of privacy. It breached the trust of the employer. They should have not been made, and finds that the employer had just cause to terminate the employee. And so the employee wasn't entitled to any severance. The recordings were made, the employee, I believe they were made for, some of it was for learning English, some of it was just because he wanted his own notes. The judge found there wasn't really a valid reason to make the recordings. And so there was a huge breach of trust, and the employer was able to use those secret recordings to justify the termination. So I think the lesson here for everybody is, it really depends on the circumstances. You can't say that an employee can never make secret recordings. Sometimes in cases where if you're being discriminated at work and the only way might be to prove that is through a secret recording, that may be permissible. It depends on the circumstances, really. If you're part of a conversation in Canada, it's not a criminal offense to record. What I mean by that is, you can't be charged under the criminal code for recording a conversation you're part of. It is illegal to record a conversation that you're not a part of, right? So you leave your phone in a room and two other people having a conversation. That's illegal. You cannot do that. In the employment law context, it's different. It's going to depend on the circumstances whether you record. Let me rephrase. If you decide to record secretly a conversation with a coworker with your boss, I would talk to a lawyer about it first, because there are nuances. There's no golden rule. Yeah, you're allowed to record always, or no, you can never record, secretly at work. It just depends on the circumstances. The case that's come out, it had very specific exceptional circumstances where there wasn't really a valid reason for the employee. I don't think he was really being. I don't know that there was allegations of harassment or anything to do with discrimination in that case. Actually, I know for a fact there weren't any allegations of discrimination in that case. So I think that before you make any secret recordings, check with the lawyer because it could backfire on you, depending on why you're making those recordings, how necessary they are. Okay, so I see we've got a few questions here. So Gina, you saying your comments aren't working. I would just type in your reply whatever you can, Gina, and just I can see your reply. If you want to just type your questions in that way, that's fine. I can still see them on my screen here. So Kevin, you've got a question. You're on a negotiating committee. You want arbitration. So Kevin, you're saying your understanding of the Bill 8 and companies can negotiate workers' right to overtime. Yeah, Kevin, I don't deal with unionized negotiations a lot. So I have some general knowledge, but I'm going to refrain from that one. And I apologize because the unionized context is just so much different than the non-unionized context. So I just don't want to give you the wrong answer there. Okay, so Belinda has a question. You're currently on medical leave from your workplace due to PTSD. Okay, 2 years. Am I still? Yeah, Belinda. So, assuming they haven't sent you a termination letter, yes, you are still employed. A medical leave, typically what happens is you're still technically employed. You might have some benefits that continue if you pay the premiums, or maybe the employer continues them regardless. The time period almost doesn't matter, Belinda. It's as long as you haven't got the termination letter, you're still considered employed. And you can obviously reach out to HR to see if you're, if maybe they sent you a letter that you missed. I've had a few cases where some of my clients on medical leave were let go while they're on a medical leave, and they just didn't get the notification that they had been let go. So there might be some issues with that, but obviously in BC, if you're let go because of when you're on medical leave, there's always that question of was it discriminatory? Because if you're on a medical leave, presumably you have a disability that's protected under the Human Rights Code, and you can't just simply be let go while you're on a medical leave, which I'm sure a lot of people here probably know that. So no, Belinda, I wouldn't assume you've been let go. The assumption is you're still employed unless you got a termination letter. So Kevin, you're saying meet or exceed. Kevin, yeah, I just don't know the answer to that question. I'm sorry. It's a nuanced question. I think will take some analysis. So I couldn't answer it sitting here. Gina asks, can your employer dismiss you on your medical leave, but if you've provided doctor's notes but not personal medical details? Yeah, Gina. So this is a good question. There's some very important nuances I just kind of want to go over. So your employer can't let you go because of your disability. If they let you go on medical leave, presumably it has something to do with your medical leave, right? So it's not that the employer can't terminate you on your medical leave. It's just they've got to prove that the reason they let you go was not because of your medical leave. And the most common example I can think of, if you're on medical leave and the whole plant shuts down, right? That's not because you're on medical leave. That's because the whole plant's shut down. So they can let you go in that situation, and it probably wouldn't be discriminatory. In terms of the details you have to provide your employer, I'd have to know more about your circumstances. I mean, the employer is entitled to some information. They're generally not entitled to your diagnosis, right? They can't ask you, okay, what's your condition, right? Do you have like depression or anxiety? They can't ask you that. Questions where it gets a bit more gray that they might be able to ask you about is, what's your prognosis, right? Like, when are you coming back to work? What are your limitations and restrictions? Those are details that the employer, sometimes are entitled to get, so that they can plan their business accordingly. So, and the reason they would ask you for your restrictions and limitations is, sometimes, they want to see if they can accommodate you, right? If you tell an employer you're going to be away for 2 years, they're probably going to hire someone to replace you. So there's some details they are probably entitled to, Gina. And there's some medical details that they're definitely not entitled to. So it's a more nuanced analysis, but I hope that helps. Okay, so Kevin, you're asking me to refer you to. Yeah, Kevin, I do know a few. If you reach out to me directly, or just to the number that's on the screen here, I can try to help you out for sure. So Belinda, you think if you haven't received any letters yet, Belinda, I'm obviously I can't tell you for sure, but it sounds like you haven't been, you're still technically employed. Okay, so Ginny, you've got a follow up. You were let go on medical leave. They asked you for personal details. Doctor wouldn't provide because I wasn't ready for accommodations. Yeah, Gina, I think if you were let go on medical leave, I don't know how long ago this was, but I talked to a lawyer about it and see if there's anything you can do. Obviously, I've actually dealt with a number of cases similar to your situation where the employee doesn't want to provide all the information, and there's some information they can rightly refuse to provide. There's always that question of, what is the company entitled to, right? What information are they entitled to? And so I think in your case, obviously, if you want to just leave it, you leave it. If you want to pursue it further, it's always problematic when if a company lets somebody go on medical leave and they're suffering from these issues, right? I don't want to say it's illegal, but it sounds like there's some issues there that need to be resolved. Okay, so I think I don't know if I miss any questions. Please just type them in again. Sorry, just got a few more questions coming in here. So Bruce says, give me an update on the Pay Transparency Act. Bruce, I'll be honest, I haven't. I might have. I don't think I've read that act end to end. I'm not in a position sitting here right now to give you an update. You're saying companies should be mandated to post their salaries and job descriptions. Yeah, Bruce, I have my own views on obviously pay transparency and pay equity. Whether the law should be one way or the other, I'll leave to a political analyst. On this show, I'll try to refrain to what the law is and not what it should be. Okay, so we got a question from Louis. You were let go because possibly you were unvaccinated. You were also harassed about the vaccine, and you used PFL during a specific time. Yeah, Louis, what is, just tell me what PFL stands for, and maybe I can answer your question. In terms of being let go because you're unvaccinated, I've talked about it quite a bit. I'm sure my colleagues have as well on the show. It's the short answer is depends on what your position is and what industry your employer falls in. Most cases, if an employer wants to let you go and you're unvaccinated because you're unvaccinated, they're gonna have to pay you severance. And so I hope that generally helps. It really does depend on what you do, right? If you're a healthcare worker, it's different than if you're an office worker. So you were on paid family leave. Um, if you're on paid family leave, that's and I'm assuming you're in BC or in Ontario. If it's a paid family leave, well, I guess the family leave under BC is unpaid. Um, I don't know if you're unionized or not. I'll just say if you're on a leave of absence under the Employment Standards Act, you cannot be let go because you took that leave. The fact that you were paid for your family leave, Louis, it sounds like are you in a union or does your employer have a policy to pay you during family leave? Um, if you can provide me those details, maybe I can try to help you out a bit more. But any leave under the Employment Standards Act, and there's quite a few of them. I can't recall them off the top of my head. But if you take a leave under the Employment Standards Act, you cannot be let go because you took that leave. The What I'll add to that is if you were let go because you were unvaccinated, um, I would talk to a lawyer about whether you should be getting some severance. I know that a lot of companies have been putting people on leave, on unpaid leave, because they're unvaccinated, um, or they've just been terminating them. Uh, Both of which are probably not permitted. And I say probably because there could be some cases in specific circumstances where it's okay. In most cases, you can't be put on unpaid leave or be let go because you're unvaccinated. If they do that, they're going to have to pay you out some severance. In terms of the harassment, Louis, I mean, it's there's multiple ways to go about the harassment, right? Um, Report to HR or WorkSafe also deals with it. In your case, it sounds like it's the vaccine issue, right? But harassment is harassment. But Louis, please talk to I'm just reading your comment. Your employer said they're listening. Yeah, Louis, talk to a lawyer. Okay, if they accept your exemption, give you a performance review. It sounds like it sounds like there's a lot going on there. I would talk to a lawyer, Louis, about if you're not in a union about getting severance pay. If you're in a union, talk to your union rep about what remedies you have or what you can do about it. Um, you know, Judges are very reluctant to especially if your employer is acting in bad faith, which means they're acting dishonestly, that does not look in front of good in front of a judge, right? If they're giving you a bad performance review based on nothing, and we can prove that, then it could result in additional damages. By damages, I mean additional monies awarded to you for that kind of dishonest behavior. Okay, so we got a question from Julia. You've never signed an employment contract. And now they're going to close our branch location. Yeah, Julia, that's a good question. So it's kind of counterintuitive, but the fact that an employee does not have a written employment contract oftentimes works to the employee's advantage. So the short question to your answer, Julia, is yes, you definitely should be able to get severance without a written employment contract. The long answer is, well, I'll give you the medium length answer. Typically, if you have a written employment contract, it favors the company, right? It doesn't favor you. In the employment contract, typically, it'll have provisions maybe limiting what you can do after you're let go. It can limit your severance pay. So, Julia, I guess the fact that you don't have a written employment contract is actually good for the for what's about to happen. Because if they let you go because they're closing their branch, your severance pay really just depends on your length of service, your position, how long it's going to take you to find a job, your age, a lot of factors that have been, they're called common law, they're called Bardell factors, but they determine your common law notice period. And so that could range from a month to 24 months, depending on, the factors I just outlined. I think length of service and age are probably the bigger ones, and obviously position as well. So Julia, I think if they do let you go, talk to an employment lawyer. I assume they're going to offer you something, Julia. They're going to offer you some sort of package. But before you sign anything, I think it's, especially if you've been with the company a long time, talk to a lawyer about the package before you sign anything. Because once you sign that piece of paper, Julia, it's hard to get out of it, right? But I hope that answer helps out with your question. Yeah, Gabrielle, you're frustrated with the COVID mandates. Yeah, Gabrielle, listen, I'm sure a lot of people share your frustrations. Again, I don't want to get into what the law should be. I'll try to do my best to stick to what the law is. Okay, so I'll take one last question here from Gina. They're saying that they had to let you go for cause because your doctor refused beyond the return to work dates. No, so I think, yeah, there's a few ways you can go about it, Gina. So employment standards is one, but they cap your severance at essentially 1 week per year of service. I say essentially because there's some details as to between, if you're over a year, you can actually get 2 weeks, but essentially 1 week per year of service, up to a maximum of 8 weeks. You can fight for human rights because it sounds like you do have a human rights case. The other option, depending on how long you're with a company, could be to go for what's called common law severance, which I was just saying to Julia, it could be as much as 24 months pay. I think, Gina, if you want to really explore the situation, I talked to a lawyer. Your situation is one that unfortunately happens, more than people think. Talk to a lawyer about what they can do. It might make sense to have a lawyer kind of go through the documents and tell you what what you should do. But you're right that there's you can go through employment standards, but there's a maximum as to what they can get you. The human rights is more complicated, and obviously the third option is it's called a civil lawsuit for wrongful dismissal to get your common law entitlements, which in some cases could be as much as 24 months of pay. Okay, so I think that's it for this week. Thanks everybody for joining. I'll be back in 2 weeks. My colleagues Darren and Dan from BC do these shows as well on a weekly basis. And I have colleagues in Ontario that do this as well, in case anybody has any Ontario specific questions. But yeah, thanks everyone for joining. I hope everybody has a lovely weekend.